This
9.
conference will now be recorded.
So we will call to order the 9 a.m. meeting of the Monterey Select Board on May 23rd. And this meeting's pretty straightforward. It's to interview an applicant for town council, Mead, Talerman, and Costa. I don't know if I pronounced that right.
Perfect.
You did.
So thank you for joining us this morning. And would you like to begin with a brief introduction of your firm? And then we'll ask questions. Does that work?
That'd be great. Thank you, Mr. Chair and members. I'm Adam Costa. With me is my partner, Kate Feodoroff, and I'm a founding partner of the firm Mead, Talerman and Costa. We're, I guess, a relatively new firm. We were established in 2016, but I'll give you a bit of background as well concerning the firm and the partners. So what I thought I'd do in these few minutes, and then I'll turn the floor over to Kate to say a few things about our labor and employment practice. But I thought I'd just give you a general overview of our firm, what we do, why we do it, tell you, why I think we would be a good fit for town council in a community like Monterey. And maybe what might distinguish us from some of the other firms. I know you interviewed a couple of other firms. I guess technically they're our competitors, but I guess I'll tell you a bit about maybe how the services we offer might differ. So we're a medium-sized law firm. We have 12 total attorneys plus support staff. We have 3 different offices. I'm based in our Newburyport office. We also have an office in Millis, which is where Kate is based. And further, we have a new office opened just a few months ago in the city of New Bedford. So obviously, all of our offices are in the eastern part of the state, but that doesn't mean that we don't have experience in Western Massachusetts. But I'll tell you a bit about that in a moment. So as I mentioned, we were established in 2016. Me, Lisa Mead, and Jay Talerman had practiced together for over a decade prior to that in a different iteration, a predecessor firm for a number of years. And we had provided primarily town council services, special counsel services, public sector for the most part. And really, our background, Jay had been a partner at Coleman and Page, now KP Law, for a number of years. So he had experience practicing in a larger firm and providing these same sorts of municipal council services. Lisa had been a former 3-term mayor in the city of Newburyport, so she had seen things from, the other side of the table, managing a municipality. And then she had subsequently served as city solicitor in the city of Somerville for a number of years as well, managing a full sort of in-house staff in Somerville. They don't use outside counsel. They have a law department. And so she had experience doing that for a municipality as well. So the idea was that we would provide a service similar to, obviously, the municipal council services provided by the half a dozen or dozen or so firms in Massachusetts that do it. But we wanted to provide a service that was, and I guess the word that comes to mind, and it's probably a funny word, is a more intimate type of town council services. And you're probably saying, well, we don't think of attorneys as intimate by any means. But I think the idea was that we would forge more of a partnership with the municipalities that we represented. We saw circumstances in many communities, and frankly, we heard this from communities that had gone out to bid for services that had used other firms. They came to us, so they came to the many firms that they might have interviewed and said, we're dissatisfied, that we feel as if town council swoops in when they're needed, when we ask for them, and then they swoop right back out. And it's not a partnership. They're not sort of a team player. We're hesitant to bring them on early on. By the time we contact them, typically it's an emergency, and they're doing what they can. They're struggling to put the fire out, and again, when they're done, they're nowhere to be seen. And we said, that doesn't seem to us like the best way to practice municipal law. It seems to us like being more proactive as opposed to being reactive, getting ahead of the problem, forging that partnership with the municipality. So there's a familiarity there, there's a comfort there. So the municipal officials aren't hesitant to pick up the phone and call us or ask us to attend a meeting live or virtually, to give them the advice they need before there's that urgency, before that emergency exists. It continues to seem to us like that's the better way to practice municipal law. And quite frankly, and we've seen this in most of the municipalities where we've been appointed as town council. It's also it's also a less expensive way to practice municipal law from the municipality perspective because putting up fires is costly. It's expensive when we swoop in and you're already in litigation or about to commence litigation. Much better to have an opportunity to provide that assistance early on, to provide that training so that there's a real opportunity to get ahead of the problem and hopefully stave off that litigation, that crisis. So we've done that in different ways in the municipalities we represent. Obviously, many of our municipalities are larger than Monterey. And so in larger communities, we have, some communities we have weekly office hours, sometimes monthly, sometimes quarterly, where we find ourselves in town hall or conducting office hours remotely through a Zoom format or a GoToMeeting format, where we open our doors and can meet with municipal officials, chairs of municipal boards and committees, staff, and have an opportunity to get to know them, give them an opportunity to get to know us, and allow for the forging of that relationship and allow the questions to be asked before the crisis arises. We offer training seminars in our communities. In fact, I'm meeting with the board next week in a community that I know is sort of poised for an incoming affordable housing project, a Chapter 40B project, and they don't have much experience with the state's affordable housing law, and so they had many questions about how they handle this public hearing, what their options are, how 40B differs from some of the other types of zoning tools, and so I'm meeting with them in a work session, public meeting, but an opportunity for me to give them sort of a primer on Chapter 40B so that they're not doing things wrong, only for them to find themselves in a position where they're denying a project they shouldn't be denying, or they're conditioning a project in a way they shouldn't be conditioning it. So these training seminars I found have been very helpful in providing board members in particular with a better understanding of matters that are within their respective jurisdictions. We also have different fee arrangements. And so we have flat fee arrangements in some of our communities, so there is not a concern about hourly billing. In some of our smaller communities, we've adopted an hourly billing format, but we try to provide for a reasonable hourly rate, certainly a rate that's much lower than the rate we would charge our private clientele, recognizing that you're utilizing taxpayer money to fund town council services. So we recognize that every municipality is a bit different. Monterey is not going to be the same as a community that is 10 times its size that we represent, and a community that's 10 times its size is not going to be the same as a community that has 75 or 100,000 residents. So size matters. Concerns of different size communities are different, and location matters. We represent communities all over the state. And so I mentioned a moment ago that this would not be our first foray into the western part of Massachusetts. I think we were recently appointed in Alford as town council. But even aside from that, we've done work in the western part of the state. We're town council in the town of Deerfield. We're town council in the town of South Hadley. And we also provide lots of special counsel services. So we provided services. I was involved in a zoning rewrite in the town of city of Pittsfield about 8 or 9 years ago. Been involved in municipal projects in the town of Lenox, city of Greenfield. We did a rezoning a number of years ago. We have a private practice as well. I wouldn't say we do much private representation in terms of the split within the firm. Most of our clientele is public, but on the private side, we've done private projects. I represented a solar developer in a friendly project in the town of Cummington 3 or 4 years ago. Had a private project in the town of Southwick. So we've made our way out to Western Massachusetts, no question. I've done work in Monterey. You may know that already. And so certainly we recognize that a city or town's location within the state matters as well. the issues that our communities are facing in Eastern Massachusetts, communities like, let's say, Marblehead, communities like Ashland or Burlington, those challenges are going to be very different than the challenges that are being faced by, let's say, Deerfield or South Hadley. We do, in addition to the 24 towns that we represent as town council, we do a fair amount of special council work where we're hired on individual projects. For example, I've represented the planning board in the town of Clinton for about almost 15 years now. And Clinton is facing very different issues than, for example, Marblehead. Marblehead is a rather affluent community. It's a community that was developed a couple hundred years ago, many nonconformity issues, significant residential base with a bit of a downtown commercial base. Clinton is a community that is looking to sort of redefine itself. Clinton has a great number of underutilized properties. And so there's been a real effort to try and bring in, to seize upon opportunities in, green energy and cannabis and things of that sort to attract a more significant commercial tax base to the community. Something, again, very different than, maybe the desires of a community like Marblehead. So not every community is the same. We recognize that as a law firm. And again, in trying to forge that relationship with you as a community and better understand what it is that you seek to achieve short-term and long-term, we hope to be able to provide a service that matches the needs of Monterey. So that's a sort of an overview of our general municipal practice. Hopefully that was smooth enough. There was a bit of feedback there with the owl, so I tried to be consistent. But Kate, do you want to say a few things about the labor and employment practice? Because I know, in my communications with the town, that some of the more immediate needs in Monterey might have, more of a labor or employment characteristic to them.
Yeah, sure. And giving you a little background of where I came from, I started my career in Rhode Island, and then I ended up in the solicitor's office in the city of Brockton, and I handled all of its labor and employment issues. And city of Brockton being self-insured, you did everything from civil rights claims that police officers used excessive force to labor negotiations to discrimination claims, right? So the entire gambit, because it's a self-insured community. So I developed quite a portfolio of experience, we'll say. And I was not looking to leave the city of Brockton. I loved working in the city, and I was approached by the firm. And one of the things that drew me to the firm was exactly what Adam touched upon, that it was a practice where the firm tried to integrate itself right into the community, because I had been working in a situation where I would have my day planned and people would run downstairs and say, "We have this issue, help." And I loved that aspect. I loved being nimble on my feet and things like that. So I was really drawn to the idea of an outside firm that was still close enough to the client whereby the client would call them on the front end, right? Because especially in the labor and employment context, doing things correctly on the front end saves you in the back end. So if you're thinking you have a discipline problem, this could lead to a termination. The worst phone call I get is someone saying, "We have to fire this person today, and here are all the reasons why." And I say, "Send me the personnel file," and it's empty, right? It becomes much more difficult to deal with that situation. Whereas if you deal with it on the front end, you start with counseling, you start with training, you start with incremental discipline, you can either encourage that employee to become better, which is the best result, and to be a positive contributing member of the town, or you slowly, progressively discipline that person until there's sufficient enough evidence to warrant a termination. My practice is not one of table flipping or strong arming, because having had my background working within the city, I recognize that these are your employees for a long time, and hopefully they'll be good, productive employees for 20, 30 years. So I don't take the position of going in and making people feel uncomfortable. Instead, I work to try to find solutions wherever possible. Sometimes you have to make tough decisions, and I'm experienced at that on that side too. But my first approach is to always try to figure out, is there a positive way forward as opposed to a negative way forward? So in that sense, and perhaps it's because of my background, I just approach things differently than some other labor and employment lawyers who are used to coming in on the litigation side. So that's my practice. That's my approach. Again, on the town side, for labor negotiations, for example, I can be as active. So some towns choose to have me directly on the bargaining team, and I would be the lead member, right? I'd be the one making the proposals, figuring out with the department heads what needs to drive the conversation, what needs to drive the collective bargaining agreement, and then putting it forward. On other towns, they like a less active approach, and they'll come to me with proposals after they've met with the employees, and they'll say, how does this work in terms of language? What should I be thinking about? And I coach it up in the background. So it really depends upon your practice, your needs, your experience on how active I can be involved. I, of course, deal with everything from grievance to arbitration, and civil service communities. I deal with civil service bypasses and discipline issues. So it runs the gambit. And now we've expanded because we've grown, really grown the practice on the labor and employment side. And so we've expanded to add a 30-year experienced labor and employment lawyer from City of New Bedford, Jane Friedman. And we have Alex Castro up on the Newburyport side, who was in the Labor and Employment Division in the MBTA. So we've really expanded. Mike Kennefick, who's really in charge of all litigation, he also handles some arbitrations on the labor and employment side as well. So that's essentially our practice on that division of the firm. And if you have any questions, I'm happy to answer them.
And before you do, I just want to add one thing that I neglected to mention before. So again, we've tried to in creating and sort of growing our practice in recent years, we've tried to identify what we see as maybe some of the shortcomings and based upon other communities' experiences or communities' experiences with other prior town council complaints that we've had voiced to us. And one of the things that I hear often is that it's like a revolving door. We use a larger size law firm, even some medium sized law firms. And every time we call for counsel, we talk to a different attorney. Every time we ask for an attorney to be present in person, virtually, we get some new associate we've never seen before. And so there's no relationship building. There's no familiarity. We try to avoid that. And so the way that we structure our municipal practice is with each community we represent, we offer a lead counsel. So our proposal to you that I submitted to you last week, hopefully you have a copy of it, was for me to be the lead counsel on the general municipal side and Kate to be the lead counsel on the labor and employment side, hence the reason the two of us are attending today. Now, that doesn't mean you're not going to, have an opportunity to avail yourself of the full services that our firm provides or to interact with the other attorneys in the firm. Again, I would call us a medium, maybe even a small to medium sized law firm. So you will have an opportunity to interact with other attorneys in the firm. You'll obviously gain the advantages of the expertise of the other attorneys in the firm. And we all do have our individual areas of expertise, largely based upon, our histories, our background. So, I began my practice 16 years ago practicing land use and zoning law. And so on the municipal side, I still handle quite a bit of municipal real estate issues, acquisitions, dispositions, zoning matters, whether it be planning board matters, zoning recodifications, zoning adjustments, things of that sort. And of course, zoning litigation. I handle appellate tax board cases. So cases that are filed with your Board of Assessors challenging the overvaluation or misclassification of properties. And again, we have different expertise amongst our different attorneys. And so you may have direct interaction. If you've got a contract issue, while your point of contact may be me, if somebody on your staff needs to go back and forth 3, 4, 5 times with us concerning a particular contract, you may be dealing with Ben Taylor here in our Newburyport office because Ben handles many of our contracts. And so certainly there's an expertise, but the idea is that you're going to be dealing primarily with me. Your point of contact is going to be me. And, unless you call me on 48 hours notice saying I need you to drive out to Monterey on Wednesday evening, in all likelihood, if you give me sufficient notice, you're going to see me at those meetings. You're going to have an opportunity to deal directly with me as your primary point of contact. So that's just a final important note I wanted to state before I turn the floor back over to you.
Thank you very much for your overview. I guess one question I have going off of the line of communication, like you just mentioned, it sounds like we would work mostly with you and then be referred to other people, other attorneys if they had a specialization. On the town side, how do you typically structure that communication from the town and to the town and other towns that you serve as town council for?
Sure. So I will tell you, there's no rule of thumb per se because it differs community to community based upon the community's preference. So I represent one community where I would describe their approach to dealings with town council as rather laissez-faire. It's a board of selectmen, 5-member board, town administrator, and the town administrator's approach, supported by the board of selectmen, is that I can communicate freely with any municipal official, board member that contacts me. I don't need authorization from the town administrator. I don't need authorization from the board of selectmen. Obviously, if I'm going to engage in litigation or being asked to commence litigation or enter an appearance in defense of litigation, I would get permission from the board of selectmen. But in that community, I field calls regularly from different board members, commission members, members of staff. Now, that's not been an issue in that community. I wouldn't say I'm contacted all that frequently. It's a community of about 13,000 residents. I would say I get a call from a board member or a staff member other than the town administrator maybe once a week. I work in other communities where if that were their approach, I would get a call once an hour. And so in those communities, they've adopted a more stringent approach to communications with town council. And that's often the case in communities where the billing is hourly because they want to encourage communication, open communication with council early on in a process, again, to get ahead of problems rather than to be dealing with them on the back end. They also don't want to open the door to free communication with council without there being some gatekeeper. And so in those communities, very often, I'll give you another example of a community about the same size, about 12 or 13,000 residents. And in this particular community, the town administrator has a contact of council form. And my experience in this community is that I can't remember the last time there was ever a denial of a request to contact council. However, there is this process that must be followed so that the town administrator has an opportunity to vet these requests and to sort of keep a degree of control over the extent to which individuals are contacting council, why they're contacting council. And when I meet with this town administrator on typically a weekly basis to provide updates on the status of matters, I will run down where those various matters stand. And of course, he also has a list of those matters because he's keeping track of them as they come through the door and as he signs off on those forms. So typically in most communities that have a town administrator or a town manager, that's our chief point of contact. I work in one community that only recently adopted that form of government. For years, they had an executive secretary. The chair of the board of selectmen, it's a 3-member board, has been the chair for almost 16 years. And he became accustomed to contacting me directly, even before they had the town administrator that they now have, because their executive secretary was part-time. And so he continues to contact me regularly, and I have communications with him, and I actually speak with him more often than I probably speak with the town administrator. So we would look to you to tell us what your preferences are, and then to the extent that you're looking to us to assist based on our experience with structuring something, whether it be that kind of a form that gets completed by board members or staff members, whether it be something less formal, communication through a town administrator or the chair of the Board of Selectmen, we can assist with that as well.
Thank you. Susan, do you have any questions?
I do. Are you comfortable, one issue that has arisen in the past, and it, I'm only on, this is my week 2 on this board, so I was very recently elected. But I've been watching town politics for a while, and an issue that has arisen in past has been problems with people feeling there was unclear passage of information from person to person. I feel like one thing that would alleviate that problem would be I know how much more efficient conversations can be. That said, I feel like it might be important for this town right now to make sure that any important items were written up in a communication so that there's no question what information was transferred in that conversation, so that we can be as, we need to make sure that the town knows that we're above board and that our behavior is completely open and straightforward, and that there's no loss of information in the game of telephone, as it were, because there's a lot of telephone going on in town. So would you guys be comfortable with that situation?
Yeah, I can
Recommendation
do that.
about protocol.
Yeah, so I agree with you that I think sometimes phone conversations really truncate the discussion because you can understand more clearly and express yourself more clearly. But what I tend to do is follow up with an email, because I agree with you. Sometimes when that information is passed on, it's passed on with, it's just less clear. So I think what we generally try to do, and this is across the practice, is have a conversation and then follow up with an email. We also, on a routine basis, provide formal memoranda to document things, especially if they'll be public facing. Sometimes I'll write a two-line email in response to a question. Sometimes I'll write a 2-page memorandum. So to your point, to the extent that you do not want information to be altered or directions to be altered, we can absolutely communicate in a written form as well.
I would say, and I think that Kate will support me in this, that one of the most frequent issues we deal with as a municipal law firm is both the open meeting law and issues that arise in communities concerning the open meeting law. The open meeting law in Massachusetts is, it's a good thing. It's a good thing for transparency. But there's also this constant struggle between transparency and efficiency. And so I've worked in so many communities where I have conversations and to my dismay, sometimes it's conversations with members of the select board or the chair of the select board that says, but it's far more efficient to do it the way we've been doing it for so many years. And I appreciate the efficiency. There's also an additional challenge in a community like Monterey where you've got a 3-member select board. And you're not the only community we represent with a 3-member select board. We represent a number. But with a 3-member board, you can't even have 2 members of the board meeting to discuss an issue without it constituting a quorum and therefore being an open meeting law violation if it's occurring outside of a properly posted and noticed meeting. So we deal with these issues with great frequency. We provide open meeting law trainings in our communities about how to communicate as efficiently as possible within the confines of the open meeting law. So I know your question was tailored more toward communications with counsel, but we see it happen all the time in communities where even in communications with counsel, we'll get an email from a member of the select board or the zoning board or the planning board, to one of us with a substantive question, copying, all the other members of that board. That in and of itself, at least under the current state of law, that one-way communication, if it can be interpreted to express any sort of an opinion of that board member, constitutes an open meeting law violation, even in the absence of a response. So So we try to provide some degree of training in our communities to kind of bridge that gap as best we can between the efficiency that's needed to run the town and the transparency that is required by the open meeting law.
Thanks. This is kind of a weird one, so bear with me, but I'm gonna make a kind of ridiculous scale with extremes, knowing that reality is in the middle, but I'm sort of asking everybody the same question. On the scale of, you should pursue this course versus here are 5 things that you could do and we're gonna give them no weight and not even guess what happened if you took them. Where would you say that your firm falls on how you approach advising your clients?
I'm going to give you a very lawyerly answer, which is it depends. And I would say what it depends upon. I regularly pick up the phone when I receive an email request for advice or an opinion, because if the party seeking the advice is cautious and smart, they're not going to tell me what they want the answer to be when they write the email to me, because you don't want that paper trail. But sometimes there is a desired response, a desired answer to the question. We play 2 roles as lawyers, and this is not unique to the municipal law practice. We can be advocates, and when I have my litigation hat on and I'm in the courtroom or I'm, preparing a brief, I'm an advocate for my client. It's not my role when I'm playing litigator to, recognize and admit the potential merit of the opponent's case. My role is to sort of espouse the merits of my client's case and do my best, within the confines of my ethical and professional responsibilities, to advocate for my client and make the best case I can on the facts that are given me for my client. That's different than being asked a truly objective question, which is, we don't have a horse in the race here. We just like to sort of know what our options are, where we stand. And so that falls on the other end of the spectrum. That's not a question of advocacy. That's a question of, we need to know where we stand. And sometimes, you can even sort of further divide that into 2 categories. There are truly circumstances where we can say, listen, you've got a number of ways to approach this. So let me draw upon, my experience in the land use and zoning context. Maybe I'm meeting with the planning board, and the planning board says to me, we'd like to better control the development of commercial and industrial properties and provide, on the one hand, some greater flexibility to potential developers and users of those properties. But on the other hand, we want to limit the effects that these commercial and industrial developments might have on our nearby residences. So how can we try to tackle this issue? Because right now we're seeing no commercial or industrial development, and we want more. How can we address this through zoning? Well, that's a perfect example of me having the ability to give you 2 or 3 or 4 or 5 different options as to how that might be achieved. You can go the route of rezoning. You can create an overlay district. You can create provisions in your zoning bylaw that would allow for the redevelopment of non-conforming properties with a special permit versus being required to utilize a variance. So there are multiple options there. There's no right or wrong answer. It's just a question of what the town is comfortable with, and there may be pros and cons to each of those things, and I would address those in my opinion. But there's no right or wrong answer. That's different than you coming to me and saying, we want to go back to my open meeting law example. We want to have a discussion on this particular topic. It's going to be coming before our board for a public hearing in 3 weeks. Here's what we'd like to do. We'd like to create a working group that's going to meet behind closed doors and is going to have a discussion about process and procedure. And yeah, they may say a thing or 2 about this incoming application. We can't really control that. We'd like an opinion as to whether we can do that or not. Well, that's a pretty black and white. You can't have a quorum of the board meeting behind closed doors, and certainly not talking about a substantive matter that is about to come before that board in an adjudicatory capacity. You just can't do that. I can't even find a way to make an argument that there'd be a way to do it. Now, maybe I can provide some alternatives. You could have a working group that consists of less than a quorum of the board. You can discuss procedure only and not talk about the substantive merits of the case that's about to come before you. So I can provide some outs or some exceptions, but that's a circumstance where I really can't give a list of options. The real answer is no, you can't do that. And it may be a tough pill to swallow, but that's the answer that we'd give in that context.
This would be for Adam, I think. I foresee oh, by the way, I should tell you that right now there's only two of us. The third member resigned, the day after the election, and we're now dealing with having to call a special election and everything involved, but that was just for clarity. That's why there's only two of us here. Again, the question, I foresee the issue of short-term rentals being on our near-term horizon. Is that something you have been dealing with in other communities, and do you feel conversant in that area of law in Massachusetts at this time?
It is. Number one, even going back 3, 4, 5, 6, 7 years before short-term rentals, was sort of in the headlines as much as it is these days. We were dealing with this issue. I litigated a case a number of years back involving short-term rentals. We've seen it. Obviously, it's more of an issue in some communities than it is in others. I don't have much of a short-term rental issue in the town of Clinton, Massachusetts, on the outskirts of Worcester. I have much more of a short-term rental issue in coastal communities that, of course, attract that short-term rental base in the summertime. We've got it in, Western Massachusetts, in the Berkshires, where you've got the tourism. It's funny you asked the question because I literally have on my screen right now the proposed town of Alford short-term rental bylaw, because they've been dealing with this very issue, and I'm in the process of reviewing it, making some red line edits to it, making some suggestions in the form of annotation. So it is something that we've been dealing with for a number of years, and I'm dealing with right now.
This one would be for Kate. So among the things on our plate is a complete redo of our our employee handbook, processes, procedures. It was due. We are in the process, I believe this week, we're participating in a 5-town group state underwritten effort to hire an HR person that would be part-time in all 5 of those towns. And part of that person's job is going to be to redo everybody's handbooks. Presumably there'll be a basic handbook and we'll have tweaks for the various towns. Would that be something that, I'm assuming that's something that happens a lot of places, that you have familiarity with it. Would you say that typically council gets involved, what part of that process would make sense for council to be involved in, both from a monetary standpoint, right? Because we're already paying that person's salary, but we'd be paying you by the hour. And from a standpoint of let's do this in a way that makes sense and not do it wrong and have to redo it.
Yeah, so a ton of experience, because thinking back, towns had everything built into bylaws, right? Which are rigid and more difficult to alter just because you have to wait for town meeting. You have to explain to town meeting why you're making these changes. And many of my communities have taken what they can take from the bylaws and put them into personnel policies. And it's what's expected now in the workforce, that you can have a comprehensive handbook to say, here's your Bible of HR for the town, and here's what all of your benefits are, what all of your obligations are, etc. So we've done this in many, many communities, and some from scratch, some compiling existing policies that were just piecemeal all over the place. I think it's important to involve town council at the front end, but then there's a point where you have to just go through and comb through what your local acceptances, for example, have been. Because think of the insurance context. Every community is different. Once you accept Section 9, then you can accept all of these other sections which allow you to pay better benefits, et cetera, et cetera. And you just have to figure that out for yourselves. And it's not a legal task. It's a time-consuming task, but not a legal task. Once that's all compiled, then I'll come back and give it another review. So at the front end, I can tell you what you need. And I have samples that you can draw from, because there's no sense in starting from scratch, because a lot of these things, your discrimination policies, they're all fairly straightforward. So at the front end, you deal with me, then you make your tweaks that make it appropriate for your community and what you offer for benefits, etc. And then you come back and I'll take another review.
Thank you. To speak to the fee proposal, it's my understanding that, from reading the proposal, you're offering $180 per hour. The town of Monterey has typically had a fixed fee agreement for general legal services. And going to an hourly rate for general legal services would be something that would be new to Monterey. And to go along with the ideas that you proposed about integrating into the community and proactive counseling, which I think are both good things, good ideals. How have you seen in other towns, and how would you propose in Monterey? Because I think with an hourly rate, people might want to use counsel more judiciously. Like you mentioned, the one town where you have to use a form, and we absolutely want to use counsel's time judiciously for your expert and your time expertise. I guess my question being, would you be willing to offer a flat fee agreement for general legal services? And do you think that that would better the proactiveness and the integration into the community, or do you think that those can be achieved through billing at an hourly rate? Well,
Sure. So that's a fair question, and I'll try and do my best to address it. So as I had mentioned before, we have a flat fee proposal that we have advanced in many communities, and in fact, it's something I like to think that I don't want to say that we invented that approach, but it's something that it has been offered in recent years by a number of other law firms, a number of our competitors. I like to think that we were sort of the first to do it, and it was really for the reason that you described when we brought on our first few communities, 12, 13, 14 years ago. We offered this flat fee approach, and it really wasn't meant to be because I like the way that my partner Jay Talerman describes this in other interviews I've attended. He says, some months we eat the bear, and some months the bear eats us, and that's sort of the idea behind the flat fee approach. It's not really that we're providing services in such a way that we're taking a bath all the time, and the town is sort of realizing a windfall, but at the same time. It's a circumstance where you have that freedom to be able to utilize services extensively one month and maybe less extensively another month. It's really provides for a better planning tool for municipalities. They can say, listen, we saw many municipalities in the months of April, May, and June really stop calling us, tell us to stop work on particular projects because they saw their budgets and they said, we've run out of money and it's only April. We can't utilize counsel until we go back to town meeting and we're into the next fiscal year. And so the idea behind the flat fee was it provides for that consistency that gives you the opportunity to plan in advance so that you recognize that you can call counsel consistently throughout the year. And even though, even with April and May often being a couple of the busiest months of the year in a municipality as you're preparing for town meeting, you're not going to have to be quite as judicious with legal services because you've had that advanced planning tool as a consequence of the flat fee. Now, having said that, we found flat fee proposals to be difficult in our smallest of communities. When we're dealing with communities of 8,000, 10,000, 12,000, 50,000 residents, and we look at their budgets, we look at their legal budget, we look at their overall budget, we look at their legal needs in terms of history of litigation. Some of our communities have flat fees that are litigation inclusive. Other communities have flat fees where it's litigation exclusive, depending upon the extent to which they've litigated in recent years. It's an easier task when you're looking at a legal budget that might be 100,000 or a legal budget that might be 150,000 to say we're going to divide that into functional segments of 1 month or 3 months and determine what the hourly or quarterly rate should be. It's a bit more difficult when you're dealing with a budget that is a small fraction of that. And when you're dealing with a community like Monterey, I don't have a sense, and certainly the two of you would have a better sense of what your history of litigation is in terms of whether you would want the flat fee to be all inclusive or not. Are we willing to have that conversation? Absolutely. I foresee it being a bit challenging in a community like Monterey, but maybe I'm mistaken based upon your history of use of legal counsel, your history of litigation. It may be an easier task than I'm contemplating.
Yeah, and for some context, we would exclude, or I imagine that we would exclude litigation from a fixed or a flat fee agreement. That's what we've typically done. We have one line for a general retainer flat fee, and then we have one line in the budget for litigation. That's what we've typically done, at least, and I would imagine that's probably how we would proceed.
And what about labor and employment? Has labor and employment been billed hourly, or has that been part of your flat fee?
I don't think it's been dealt with.
It's,
Sorry, Melissa, or I just caused a problem with the TS test.
yeah, I mean, that would be something that I guess we would have to figure out. I guess it's been my understanding that general employment matters might have been considered under the general legal services agreement, and then if something adversarial arise, then it would be billed hourly. But I guess I just wanted to see if you're open to the flat fee agreement and we get to that point. It sounds like you are open to having that discussion.
We absolutely are. One thing that I tried to do in preparing the proposal, and specifically the financial proposal and choosing the appropriate hourly rate, I would tell you that's the lowest of the hourly rates that we're offering to any of our communities is $180 an hour. I know most communities have upped their rates to as much as $250 per hour, firms in many communities, and we tried to be reasonable in light of municipal budgets, and specifically in this case looking at Monterey's municipal budget. We also looked at travel time. I mean, the reality is, and I'm comfortable saying this because I've looked at the other two firms that you're interviewing, and they're not really any closer than we are. We may actually be closer with our three offices, but I recognize that if we choose an approach similar to the approach we have in most of our other communities, where we bill portal to portal. So if I'm leaving Newburyport and I'm heading to the town of Berkeley, where we're town council, which is just south of Taunton, it can be an hour and a half. I mean, I don't typically charge for traffic, but it's an hour and a half to an hour and 40 minutes each way. So it's upwards of 3 hours round trip just for me to attend a meeting, not including any of the meeting time. Now that's an hour and a half, 3 hours round trip, plus or minus. You start talking Monterey, it can be 3 hours from Newburyport to Monterey each way. So recognizing that a 6-hour bill for round trip travel was far too excessive, we did propose in our submittal that we would cap round trip travel at 1.5 hours. So we tried to be realistic in recognizing the community that we were making a proposal to, and what your needs would be. But if there's a way to work that into a flat fee arrangement, so we're not getting burnt because we have a flat fee and you're requiring us to attend 3 live meetings a month. And so that's 18 hours in the car before we even perform any legal services. If we can structure a reasonable flat fee proposal, that's certainly a conversation we're willing to have.
That follow-up question there would be, in the age of Zoom that COVID has brought us, which has many advantages with regard to things like this, what do you think, besides town meeting or special town meeting, which clearly we prefer to have someone present for, what do you think usually warrants an in-person visit versus a phone call or a visit?
So I think that
go ahead.
Go ahead, Kate.
Sorry.
No, go ahead, Kate.
From my side, I was really reluctant to do a lot of the labor and employment stuff via Zoom, but I was pleasantly surprised. I just negotiated a contract in a Western Mass town completely via Zoom. And I didn't think that was going to work, and it did. I do think discipline hearings, and maybe this is me being a dinosaur, I don't know. I think discipline hearings warrant in-person meetings, just because it's a sensitive topic. It's an important topic, so you need to have sufficient advocacy. And I find that face-to-face is you're able to advocate in a way that you can't via Zoom. I've done several arbitrations via Zoom, and it just wasn't the same, perfectly honest. But all the day-to-day questions can be done remotely, bargaining remotely. All of those things I found work really well remotely.
And I think on the general municipal side, the answer is sort of the same. So we were all a bit reluctant to utilize and to rely upon Zoom and GoToMeeting and these virtual formats, not long after the pandemic arose. But we've all become accustomed to them. And I'd like to say I'm much better at Zoom and GoToMeeting and WebEx than I was when things started, in terms of not just my familiarity with the software, but my ability to communicate utilizing these platforms. Still, it can be difficult with the more important, more controversial matters. And so, I'll give you an example of something that I was involved in, that the town didn't want to incur the cost. It was an hourly community. They didn't want to incur the cost of having me physically present at a meeting. I recommended that I be physically present. They told me they only wanted me by Zoom. And I suspect that they, after the fact, wished that they had sort of heeded my advice, because we knew it was going to be a particularly controversial matter. It was a matter before the town zoning board of appeals. We had an applicant represented by counsel. There was a history involving this particular property. We had a handful of neighbors, not represented by counsel, but very much in opposition to the proposal, who had been vocal in town hall with town officials. We knew that they would be in attendance. And we had a board that didn't have a particular familiarity with this sort of nuanced issue. So I had provided an opinion in advance in writing concerning the nuanced legal issue. And I had a conversation with the chair, and I had a conversation with the staff person for the town that would be in attendance. But the problem was the meeting got out of hand, and I knew from the get-go that the chair was likely not the kind of personality that was going to be able to sort of take control. And he didn't take control, and the meeting got out of hand. And I feel that had I been there in person, I would have had an opportunity to provide some structure. Again, I've been doing this for 16 years. I attend meetings 3-4 nights a week, planning boards, zoning boards, select boards. I like to think I have a sense as to how to maintain a degree of decorum. And I would have liked to think that I could have handled things a bit. That the chair could have deferred to me on some of the more controversial legal issues. When I say it, maybe people are less likely to argue. So there are circumstances where it's worth the investment of time. It's worth the additional effort to be present physically. But for something that's relatively non-controversial, an executive session with the select board to discuss whether I'm going to file an appearance in a lawsuit, or to ask about, an issue of potential acquisition of real estate under the real estate exemption, it's going to occur at the end of a meeting for 15 minutes. There's no reason for me to drive 3 hours out to Monterey, 3 hours back, to have that 15-minute conversation that can be had through a platform like this.
Thank you very much. I think that answers all the questions that I had.
Me too.
Really appreciate both of you joining us today for the interview.
Greatly appreciated. It was very nice sort of meeting you.
Yeah, nice to meet you too, and appreciate you making the time to do this. I know you interviewed a couple of other firms last week, and really appreciate you holding out and at least giving us the opportunity to meet with you and to make our pitch. And again, if you have questions about our proposal, feel free to ask. If you want to have a further conversation about different financial options, happy to have that conversation as well.
Thank you so much.
Thank you. Have a good
great day.
You too. Thanks.
Bye now.
Bye.
Bye. That was interesting.
Okay, so that
Oh, God, now we gotta make a call, right?
was the interview. And I guess the next item is review of legal counsel interviews. I'm hoping to put on Wednesday's agenda appointment of counsel, and we could use the next couple days if we wanted to check any references. But I don't think, it wouldn't be bad now to get a sense of where we are at.
I agree.
I guess.
How are you feeling?
I was pretty impressed by the Mead, Talerman and Costa interview. I think their willingness to offer, or at least discuss a flat fee agreement is something that Mears and Harrington and Leonard Kopelman seemed pretty against last week. I also noticed, if I'm not mistaken, they bill, if we do go hourly, they bill at 2/10 of an hour minimum instead of 1/10 of an hour minimum. Which is maybe a minor difference, but, and then Leonard Kopelman, I mean, if we are to go hourly and try to make it within the budget, his minimum was 1/4 of an hour. So it seemed like a lot of day-to-day things that would be quick, he might not even necessarily bill. But money's not the only concern.
I was concerned about even Copeland's response to our request for references was a little, I would call it vague, muddled, and not on point. It didn't really address what we asked for, which is a concern for me, because I felt like that was a pattern evidence in the original interview. He meandered a lot in his answers, which could explain why he doesn't bill for anything less than 1/4 hour. It may take him 1/4 hour to get to the point. I agree with you. I feel like both Mead, Talerman and Costa and Myers and Harrington, I felt like all of the attorneys, like, they're good listeners. They understood what we were asking our questions, and they gave us answers that were on point, and, I felt clear in both cases. I do feel like, Ms., is it Feodoroff? Getting my name wrong. Feodoroff, has a lot of relevant experience concerning employment law, and might be an asset, especially this coming year. We're getting everything, employment practices reviewed and in place is gonna be an important thing. The more experience someone has, the more structure they can give you for that process, which I think is helpful. Not that I think Donna Brewer doesn't also have experience, but the way that Kate put herself forward made me feel like she understood the issues we'd likely be facing. And I suspect Donna does too, but. And I also appreciate the fact that they'd at least be willing to talk about a flat fee. Any other thoughts?
Well, yeah, I think it would make a lot of sense for the town to have a flat fee arrangement, because the numbers are pretty scary. Even at $180 an hour, we get something like 9 hours a month. And I asked the question, it seems to me if we can only use counsel 9 hours a month, how are they being integrated into the community and doing proactive work?
I thought your question was very perspicacious.
It would concern me. We've never, Melissa, correct me if I'm wrong, but put litigation in a general agreement.
No,
Yeah.
Originally when we had Jeremiah, we had just one line item, but I think we maybe had one case in like 10 years.
Right.
And then I believe when the ZBA one came up,
Right.
Hume, he suggested that we add another a line item.
Okay.
So that was
Which
just-
seems appropriate, cause
Right.
litigation, first of all, you wanna try and avoid it, Second of all, when it does come up, I think it can be awfully hard to predict, and you don't want them changing you.
Right, and the, like, the issues like with Mike Johnson, that was covered by insurance.
Right.
We didn't have to have a separate litigation, item for that.
Right. So, yeah, any other thoughts?
No, I guess if we want to spend the next couple days checking references and then kind of make a decision on Wednesday.
Do we wanna divide and conquer on that only so that we're not both calling the same people?
Sure.
How can we do that?
I'm most interested frankly to know Stockbridge for, Mears and Harrington, Alford. It sounds like Alford's new to,
Yeah, they literally just adopted them.
so
as
then
town
maybe that
board.
wouldn't really be helpful, but
No, probably not.
So I did speak to the town administrator in Stockbridge when you guys asked me to call, and he had nothing but good things to say about Mears and Harrington. He said that they're very similar to KP Law in their approach to things. He found that they were very responsive to calls, usually within a day to an email.
but their flat fee agreement is more than twice.
Yeah, he
what
didn't
we-
really explain it, but he did say that they have a pretty open arrangement where everybody can contact. And he didn't explain why it was so high there.
So
I can call him
yeah.
back and certainly ask.
What is our current policy? Cause you guys worked on this
The
last
current-
year.
The current policy is that really requests to go to council are supposed to come to the select board. So if the bylaw review committee wants to contact council, which they did, let us know, okay. And their request is a little bit different because they want the select board involved as well. But let's say the renewable energy working group, they've been working on renewable energy, they came up with they got to a point where they have a bunch of legal questions, they wrote to the select board just puts it on an agenda and says the renewable energy working group wants to contact council. Like he said, it's almost always gonna be approved once people go through the motions, but it just makes people think about use of council. And I think in some ways that's probably a smart decision, whether we have a flat fee agreement or hourly.
I
Because if we
agree.
have a flat fee agreement and everyone is CCing council on things, which happened a lot last fall.
Right.
People were just CCing council on things that had nothing to do with anything legal.
I kinda like that form right here, I'd like to see what it looks like.
Yeah, I like the form idea. I think whether we do a flat fee or an hourly, it just makes it so that contact of council is orderly and judicious, because
The one thing I would add, and I haven't had a chance to look back over this to see, is that I think that when we do give permission, we should add on that the town administrator will email council to say that the select board has approved such and such a person to contact them.
Yeah.
So that it's clear that like, this person who's calling you, it isn't random or uncalled for. Like, we have this policy, the person went through the policy, here's their permission, take their call.
Yeah.
We didn't have that part, did we? I didn't look at this yet, so.
or the other thing would be to really have one point person put the questions in writing and CC the chair of the renewable energy working group or bylaw review committee. So that all the emails are coming through one person, and then, the chair, whoever is asking the questions can get the responses, but they're not getting emailed.
Right, but what I meant was, let's say, the Renewable Energy Commission
Mhm.
committee comes to us and says, we need to contact council, and we
Yeah.
say, okay, that's great. The chair of the committee can contact council, but once we've said that, the TA should email the law firm to say, this person, the chair of the Renewable Energy Committee, has received permission to contact council with regard to issues before the committee.
Yeah, or if they write questions to us in the first place, we just
We can do
send
it
the
on their
questions
behalf,
and
absolutely.
CC them.
Right, but if we are granting permission for them to contact council directly,
Yeah.
we should email council to tell them that that permission has been granted. That was the piece I wanted to report. I personally can say, I am comfortable, with either Melissa or you contacting council once we've agreed that that needs to happen. And especially if council is going to be following up conversations with a written response. Because I feel like if they're following up with a written response, it will be clear what that message is and it can be delivered to everyone relevant in a timely fashion. So everything will be clear.
Yeah.
That's how I feel, like, I don't know how anybody else feels, but I think that's okay.
Well, and I guess that's something to work on too, and it depends in part on whether we end up with an hourly or flat fee agreement, but either way, you want to use council judiciously.
I think so, I think no matter what we wanna use, because we don't want them at the end of the year to be like, yeah, we have to go to an hourly rate because you guys are like,
Yeah,
Logging
or
us with constant
resign,
things.
or
resign,
yeah.
right, plus, I just think it makes sense from, like, we should be judicious in our use of counsel because we need to make some decisions for ourselves, you know,
Yeah.
and not everything is a question of litigation, and shouldn't be. But also, I just like the idea of having something I can refer to and I don't have to rely on my memory every time, I can go look at the document and make sure I'm clear on what was said.
Yeah.
That is preferable for me in general.
Yeah.
So.
Alright, so we'll take this back up on Monday. Are there any comments and questions from the member of the public? Alright, I'll
You
motion.
meant Wednesday when you said, right? Not Monday? You said take it back up by Monday?
Sorry, Wednesday.
I wanna add one more thing, we never finalized, so we have some feedback from Stockbridge. Do we need, does one of us wanna contact somebody in Stockbridge? I mean, I guess it would just be the TA and not the select chair, but you talked to the TA or TM? Whatever.
Well, you know what, because we should probably all, I think it's worth everyone checking references
Yeah, I
if
think
we're
you
going to,
should.
rather than, oh, well, you know, he
So that
told
doesn't-
me,
right.
yeah,
Here's what I'm thinking.
which could get cumbersome.
There's a list at the end of Myers and Harrington of their,
And I know we asked for references, but we can always just go on the town website and call.
sure,
for it, right?
but I'm just thinking, so they have a bunch of towns here for Costa,
Yeah,
MTC, whatever. Do we wanna, like, I don't know anything about any of these towns, so it's just completely random from my standpoint.
so Deerfield is out west, it sounds like they've been working for Deerfield for a while.
They're not actually on this list, but we can. certainly
Well,
look
so
them
this
up.
is
Yeah.
on the first page, on the first
Right,
the first page of the,
yeah, no, I know they work for
Proposal.
Deerfield, I just went to the references list at the end, so that they're like actually giving us phone numbers for people.
South Hadley is out here. Not that we only have to call people in Western Mass, but if you wanted to get something that might be somewhat representative.
I'm just looking down this list, I don't even know where's Burlington, Massachusetts?
In Vermont.
I don't think so, is it? It does have a 781.
No, it's probably.
Lunenburg, where are these places? Looking down the list of things that are actually on the references list, do you recognize any of those of being small-ish towns, either of you?
Burlington is in Middlesex County
Okay, so
with a
eastern part of the state.
population of 26,377. What was another one you mentioned?
Let's see, Lunenburg, Lunenburg. I'm just trying to pick us some
Yeah.
communities so we can divide and conquer and not be calling the same people and pestering them, but I agree, Deerfield and South Hadley might be good places to call.
Lunenburg is in Worcester County with a population of 1,760.
1,716, so that's actually small.
Mhm.
I'll take them. Maynard?
I believe that's out. Maynard has 10,746, and that's also in Middlesex County.
How about Millis, Millis? Definitely never heard of them. Kingsborough?
Millis is 8,460 in Norfolk County.
Thoughts?
Uh,
Do you have any?
I don't know,
How about this? I'll take Fairfield, you take South Hadley.
And from the RAs, she's using Jim Willis, she mentioned him.
yeah, she works for Tri-Town
Right.
and BRPC.
Right,
Right.
Yeah.
So you wanna do one and I'll do the other? Which one you wanna do?
I can do Jim Willis
Okay,
and South Hadley. And I am gonna reach out to New Braintree for Copeland and see how they're liking it. Cause I think he seems, just interested in finding solutions.
I agree.
And the quarter hour billing is a good thing. I don't think he's really, he said, I think, right, one town, he's only ever had one town go over budget since he's been off on his own, which
Yeah.
is, I think, indicative of his billing practices. And he started Copeland and Page, right?
He has a lot of
Copeland.
experience.
So I don't doubt that he is an effective town council.
I just felt like when we asked questions, a lot of his answers were very, very vague and meandering. And that is a problem for me in general, like I prefer someone to get to the heart of the matter a little more expeditiously.
Yeah.
So, but I totally see your point in terms of the financial issues, there's no question, and you can't argue that he doesn't have experience.
No, I mean, he has
Clearly does, right,
more
yeah.
experience than
Well, yeah,
anyone.
I, for sure. And I'm probably gonna call at least a couple of these other towns, I can
Yeah.
look through which ones,
And if we call the same people and they have to answer twice,
then they have to answer twice.
doesn't hurt us.
No, it doesn't. I just don't want them to, be like, what's that I just came from? Alright, so we have to, I suspect, even when we come to the decision, then we have to go forward with, asking about, especially if it was MTC, we'd have to go forward with the next process, which, well.
Well, we can have that discussion, whether we can just agree to the hourly rate or whether we
Right.
feel that we should ask
It
for
was
a
asked.
flat fee. I think, I'm of the opinion that we should at least ask for a
I
flat fee
agree.
agreement. And I know KP last year, was willing to meet what they knew we had approved. It kind of puts them in a tough spot, but it's advantageous for us, like, hey, we have $19,000 approved. Can you do it for that amount of money or not? And there's not really much of if they say no, we just don't
Right.
have that
Or
money.
we just don't have that.
They could do it and we can try and come up with an extra few $1,000s, through a special town meeting or something. But
And if, the one thing we might have to consider how we wanna deal with, and I'm just suggesting we think about it in advance, is that they might also come back and say that, both litigation and labor are outside, which, might be awkward this year. In other years, I don't think it would be a problem. But this year in particular, so the one other question we might wanna consider is whether the monies we approved at town meeting for HR, where we took away the specificity, whether those
Yeah.
monies might be able to be used towards legal fees specifically for the employee handbook and related issues.
Yeah.
Does that make sense?
yeah, we can have that, we can cross that bridge if we get to it.
Right, but I'd like to know in advance if that's even an option, because it might.
Well, it's up to us, we can spend money and if the accountant will cut the check.
Right, well,
Yeah, she's
okay,
just gonna wanna make sure that the intent of that money was for something like that, so as
Yes.
long as we can justify that,
Yeah.
she would have no problem.
So,
that was, I just wanna know.
yeah, but you
what our
can go and
options
ask counsel legally, can we do this? or
Right,
that?
right,
But
right.
at the end of the day, it's really, if we are comfortable doing it, whatever we're comfortable doing.
Absolutely, and you know, if it was specifically for that project, I feel like I'm okay with it, but I don't wanna make assumptions about what's legal or what you feel.
Yeah,
Or
well,
what
I'll
the
have to look at the wording
Okay.
in the minutes, but, alright,
Alright,
motion to adjourn
second,
the meeting, and I will vote yes,
yes?
meeting is adjourned.
Alright, before you leave, I do have the payroll warrant,